Well, hello everyone. How are you doing? This is a rare pre-recorded episode, as I had promised a brief summary, just the facts, or almost just the facts, ma'am, of what is going on in Michigan, and I seem to be incapable of brevity on a live stream, so let's see if I can do it on a pre-recorded. And in order to keep myself on track, I did jot down some notes, so apologies if I am doing a little bit of reading, but I wanted to get people up to speed that don't want to watch hours of video or get too much into the weeds. So, are you ready? You strapped in? Let's get started. So, I am going to try to stick to the bare facts as much as possible, and also try to correctly and simply represent where there are disagreements. That does not mean I'm not going to give any opinion. That's going to be impossible, and my ultimate opinion, obviously, is quite well known. The LNC has recognized an affiliate. So even though there might be an apparent dispute, allegedly, in Michigan, in fact, there is a recognized affiliate in Michigan, and it is that affiliate I support. Let me get that bias right up front. But I wanted everyone to know how we got there. In a way, again, that doesn't go too much into the weeds. Now, the whole issue in Michigan is about rules and process, and whether you can just disregard the rules and processes without consequences when you don't agree with the results, rather than pursuing your rights within those same processes. You know, I can speak from personal opinions. There were things the LNC did to me last term I didn't agree with. I went through the processes. I went through a judicial committee. I didn't agree with their decision. But you know what? That is the processes we had in place. I continued to work within the processes and then brought it up at a duly convened convention, at which point I do think the right result was achieved. But that took a while, and I couldn't just go start a rival LNC because I was upset with the results within our processes. And when you're in a voluntary association, that's the way it is. You win some, you lose some. But the bylaws and the rules, quite literally in law, are the contract between the members and the entity and to each other. And you can't just disregard them when things turn out in a way that you don't care for. Or at times you may disagree with an interpretation that is reached through the proper processes. That is part and parcel of being in a voluntary organization. And I, of all people, know what it's like not to agree with certain conclusions. So, when I use the word, or if I use the word illegal in any of this discussion, I don't mean that in the sense of like the laws of the United States of America or Michigan. I mean it in the sense of against the rules or against the processes. I use it as synonymous with illegitimate. Also, I want to add here, this is not about caucuses and factions. It should not matter who you may ideologically agree with more. You can't cheer on an illegitimate means because the person using the illegitimate means is someone you like, unless you also will be fine for that precedent to be set to be used against you. Because there's a pendulum. Different groups at different times may be in whatever little power there is in the LP, and you need to be consistent. So I ask everyone to put aside any potential factional considerations they may have, who you may like, who you may do not like. As I said before, the bylaws and the rules are the contract between the members and the entity, and of all things, libertarians believe in contracts. Also, the rules are not random. There are principles, another thing libertarians understand, that undergird rules. And of course, those can be tweaked in the bylaws. But when you're dealing with parliamentary procedure and the bylaws, which do supersede that, there are some certain types of rights protection that's built in. There are the rights of the majority. I think we understand that. But the rights of the majority are protected provided that the rights of the minority and the rights of absentees are always protected. That is part of the process. We are not mob rule. One can't simply say, but X number of people voted for something. If those other rights are violated, if the rights of absentees aren't protected, if the rights of what Roberts would consider is a significant minority, which is generally 1/3, is also protected. This is just basic parliamentary philosophy in the type of entity that the Libertarian Party is. And the rules of Michigan and the rules of the National Party are set up within this framework. Again, making this factional and violating the rules because of faction is just completely inappropriate. And in voluntary groups with rules, again, there will be decisions you think are wrong. It's the nature of the beast. You live to fight another day. So, deciding to throw away the bylaws because of decisions one group did not like and not have the patience to set this right following proper procedure is the entire theme of what happened. So here's the short summary of how we got here and why the rival board is, in fact, completely illegitimate. And they are illegitimate regardless of whether or not their opinions of various decisions made are right. Because if the decisions made were done within the proper process, people are going to differ. That's just the way it is. And throughout most of the summary, I'm going to take some of their positions as correct for the sake of argument, or at least plausible for the sake of argument, to show that it's still irrelevant to the ultimate conclusion. They could be completely correct that the decisions made under the bylaws weren't good decisions and still be completely and utterly wrong about the actions that they took afterwards, which they are. Both under Michigan rules and I believe under every law, though ultimately, as I said, I'm not an attorney. I hope it doesn't come down to a court of law having determined this, but it might end up going there. It is the obligation per the national bylaws for the National Party to recognize only one state-level affiliate and to defend that affiliate's battle access and its rights to the extent we can, because one of the purposes of the National Party is to charter affiliates and to support their growth, which includes ballot access, which includes protecting their brand and the National Party brand against other groups illegitimately claiming to represent that brand, which are then taking donations from people under that, because that would be fraudulent. Prior to the National Convention in Reno, Michigan had a duly elected and uncontested board and judicial committee. That's where they stood right just prior to Reno. The judicial committee under Michigan's bylaws are given the authority. They're given very broad authority compared to some other affiliates' bylaws to decide disputes under their bylaws. So if there's an allegation that the bylaws were violated, the ultimate decision rests with the judicial committee. To wit, this is what their bylaws say. The judicial committee shall decide cases involving alleged violations of these bylaws or resolutions. So that bylaw is completely clear. And it is the bylaw which almost all of this controversy hinges on. You don't have to like or agree with the power given to the Judicial Committee here. It is what it is. The bylaws that were duly adopted by Michigan delegates gave the Judicial Committee that power. They may have buyer's remorse right now. There's a way to correct that within the procedures. That is their contract with the members. That is what members who have paid dues and given time have a right to expect to be enforced. After the National Convention in Reno, several members of Michigan leadership were unhappy, and that included the then chair and first vice chair. They have a first vice chair and a second vice chair, and they resigned soon after the National Convention. The second vice chair, Andrew Chatterdon, I always mispronounce his name, then auto-ascended to the chairmanship. There was an internal dispute over whether or not this was correct. It seems to have been resolved in that it was correct, and I happen to agree with that decision, but this ultimately doesn't matter. There is certainly good argument that this is absolutely procedurally correct. The differences that people had with the auto-ascension were more philosophical in nature, and that philosophical objection was that the membership of Michigan should be able to select the new chair. There shouldn't be auto-ascension. I'm going to add in as a side here that the trigger for all of this was the resignation of the chair and vice chair. Who are now weighing in on all of this, even though they resigned their positions. If they had thought this through and resigned with a little more thought and planning, they could have planned, they could have gotten a special convention called, and had a more peaceful, transfer of power. But I believe they impulsively resigned, and that caused this whole thing. Lesson for the future. Those members who philosophically disagreed with the auto-ascension had many options in order to realize their desire of members selecting a new chair. Doesn't really matter at this point what those options were, because we're going to deal with is what in fact happened. Now, Michigan has several kinds of conventions in their bylaws. A recurring problem here is some poorly written bylaws that require interpretation. And a nominating convention for Michigan candidates was already scheduled for July 2022. Some of the executive committee members and probably some party members who wanted the delegates to elect a chair decided that they were going to get to that point by making a motion of no confidence against Andrew Chatterdon. That is allowed under their bylaws. It's somewhat unusual, but it's basically a removal motion. A motion of no confidence is not something that exists in Roberts, but they do have a rule for that in their bylaws. It is disputed. One side alleges, and I've seen evidentiary proof, that this motion was used just so that the delegates could elect a chair, even though they really didn't have grounds. It was kind of an artifice. That's one side of the story. The other side of the story is that they had grounds. Again, none of that is particularly relevant. Just wanted to properly represent both sides. And a related issue is that there were also multiple other vacancies in the executive committee. And the same people wanted the delegates to fill those vacancies and not the board to fill those vacancies. However, it is crystal clear under Roberts, and a lot of affiliates run afoul of this, and it's a rule they might not know. In order to fill vacancies, unless your bylaws specifically carve out an exception for this, a certain amount of notice is required. You have to give notice of filling vacancies. You can't just add it to an agenda. even if it was the type of convention or meeting where you can freely add things to the agenda, you can't add things that require previous notice, like bylaws amendments. You have to give previous notice for those in most affiliates. Any actions taken in violation of notice requirements are generally speaking null and void. And that is because notice requirements are a rule that protects absentees. Notice requirements are pretty much sacrosanct. You run afoul of them, the actions taken are null and void. This is really super basic. There's also certain notice requirements required for the motion of no confidence. And one of the other issues was, is the nominating convention a regular convention or a special convention? At a special convention, only items specifically noticed, and they have very specific notice requirements, and their bylaws can be heard. At a regular convention, certain items of business can just be brought up. There were various parliamentary opinions on that. Some said it was a special convention. And, well, if you want to talk about official parliamentary opinions, one said it was a special convention. I believe two said it was a regular convention. I think all of them said there's room for ambiguity here. So it required interpretation. I can tell you that one of the rules of interpretation is if one of the interpretations renders another area of the bylaws absurd, the interpretation that doesn't do that is the correct one. Now, I know some people will disagree with me that deeming it a regular convention rendered other parts of the bylaws absurd. My argument for that was it says officers are elected every regular convention, as is the Judicial Committee. So you would have to be doing a whole election. I firmly believe it was a special convention. Again, this is a matter of interpretation. And turns out what my interpretation is, what any parliamentarian's interpretation is, ends up being irrelevant. But just so you know that was an issue. So at the nominating convention, Andrew Chatterton was removed through a vote of no confidence, and the multiple vacancies were filled. And the chair position was filled by Joe Brungart. There's lots of allegations from all sides over these events. Again, they are irrelevant to the ultimate facts. Mr. Chatterton appealed under the bylaws approved procedure his removal, and he also appealed the legitimacy of filling the vacancies. And he appealed these to Michigan's Judicial Committee, which is their process. And under the bylaws, the Judicial Committee decides these matters. Like it or not, those are the rules. And that's why I said all of the various prior interpretations are irrelevant, because the final buck rests with the Judicial Committee. It's their decision that ultimately matters here. So the Judicial Committee in December found in Mr. Chatterton's favor, which then said, and in their ruling, they said because of violation of notice, and remember, notice is one of those sacrosanct things, that the removal of Mr. Chatterton was not properly noticed, therefore null and void. The filling of the vacancies were not noticed, therefore null and void. So those elections were voided. Those persons never validly occupied those seats. So Mr. Chatterton was recognized as the chair, and those vacancies were vacant. The Judicial Committee wrote a very well-written opinion. You don't have to agree with it, but they did support their conclusion plausibly. They supported this decision by citing the bylaws and the rules. One doesn't have to agree, but this is the proper process. Members who were unhappy with the Judicial Committee decision petitioned. This is already turning out longer than I wanted, but I'm sorry, this is the short version. Petitioned for a special convention to deal with these issues, and that's their right, and that is the proper way to handle. And here's where more poorly written bylaws come into play. There was a conflict in how soon a special convention could be set. The board, who has then the responsibility to interpret that, chose the interpretation in which there was no chance of making the results invalid. They chose the safest bet. If the members thought the board decided wrongly, they could have appealed that to the Judicial Committee. They chose not to. The convention was set. A venue, a deposit was put on it. Notice was sent out because this was petitioned. The unhappy members petitioned. They demanded a convention, and it was set. It was all ready to go forward. It was set for April 1st. All they had to do was go to that convention and win. That's the way you settle these disputes. However, and I have no idea why they did this, people can speculate, it's not helpful. Instead of following that process, some people think, again, maybe they didn't think they had the votes, who knows? They decided that the board, with Mr. Chatterton as chair, and those vacancies being vacant, wasn't the right decision by the JC. And they said, we can just disregard the JC's decision. And basically saying the JC's decision doesn't go into effect until the board that was in existence at the time the JC decision was rendered accepted. Obviously, since it's very often the board that's appealed, that is an absolutely ludicrous interpretation. A board that got appealed obviously is not going to agree with the Judicial Committee, and they could just go, okay, we're not going to accept your decision. That renders the members' rights to appeal meaningless and empty. But of course, that isn't what the bylaws say. The bylaws say the Judicial Committee decides. And once that happens, that is, in fact, the state of affairs until changed in a convention. But they decided they could just disregard it. That is completely flouting the bylaws. That's not what they say, and again, it's illogical. Now, they gave many reasons why they thought the JC decision was wrong and even in void. But even if you agreed that their reasons had merit, the bylaws don't give them the authority to void a JC decision. They don't have that authority. Their bylaws give the buck stops here final authority with the Judicial Committee. They also attacked members of the JC's integrity, claiming all sorts of bias and conflicts of interest that are not in their bylaws. Nothing that they accused them of, even if it was all true, is a bylaws reason to disregard. All of these alleged biases were known by the delegates who duly elected them, and you respect the decision of a proper election at a properly noticed convention. They just did not have the right to void it, even if you take all of their assertions as correct. What they did have the right to do was demand a special convention, which they did, and all they had to do was attend it. It's still set for April 1st. But what they chose to do instead is just set up a rival board of directors. That's just not legitimate. Imagine that happening in your state. Now, the argument they are relying upon now that needs to be dealt with is the claim that since the board is incorporated, that the Judicial Committee violated the state law of Michigan by removing elected directors. This argument fails on multiple points. First of all, they're citing the law incorrectly. So that right there ends the argument, and I'll prove to you that they're doing this. But let's even pretend that they're citing the law correctly. No elected directors were removed. Declaring an election null and void means they were never elected. It was not a valid election. You cannot remove somebody who never validly held the seat. The Judicial Committee decision did not remove anybody. It voided certain actions. Void means as if they never existed. So nobody was removed because nobody was validly elected. They declared an election void ab initio. Okay. Now, I'm going to... The legitimate board hired an attorney to give an opinion on Michigan law when it comes to corporation. And here, and I do apologize, the rhetoric's going to get a little bit more intense because there was some bad faith here in the way this law is being twisted. I'm sorry, there's just no other way to put it. So, their attorney stated, the Michigan nonprofit corporation known as the Libertarian Party of Michigan Executive Committee, Inc., does not have members. Notice, he said the corporation known as the Executive Committee, Inc. does not have members. We will deal with that in one moment. According to Article 4 of the Articles of Incorporation, this nonprofit corporation is organized on a directorship basis. Please keep that in mind. There's no reference to members. Consequently, because it is organized on a directorship basis and has no members in law, and in fact, any reference in the law to a member removal requirement, and then he quotes the Michigan statutes, is misplaced. Okay, 1 second here. There's more that I don't need to read. He notes that the bylaws of the party are incorporated into the Articles of Incorporation. People become officers of the corporation via election as officers, or whatever name that they use there, of the party. Now, I have the attorney's letter right here. So you may have had the same, I would have had the same very knee-jerk reaction when he said the Libertarian Party of Michigan Executive Committee does not have members. You'd be, oh my God, the party does indeed have members. And that is the rhetoric that's gone. That this attorney said we don't have any members in Michigan. No, that's not what he said, because the next paragraph says the Libertarian Party of Michigan exists separately from the Libertarian Party of Michigan Executive Committee and controls the Libertarian Party of Michigan Executive Committee. And then he goes on to describe members of the party. So in the part of the letter where he said there are no members, he didn't say of the party. This is a legal distinction in the nonprofit code in Michigan. A nonprofit corporation in Michigan, if you read prior to that section that they quoted, is organized on one of two bases: a directorship model or a membership model. The Articles of Incorporation, Article 4, state this corporation is organized under a directorship model, not a membership model. Those later laws that they're citing are for corporations organized on a membership model. They are completely inapplicable to the type of corporation that this one is organized as. So they are completely misusing the law. They are citing a section of the law that does not apply to the kind of nonprofit corporation that they were set up as. Now, to make things a wee bit confusing, even corporations organized under a directorship model can have members. However, those members have no voting rights. So, if the illegitimate board is going to be consistent in appealing to Michigan law and insisting that that applies to the party and not just to the board, they would have to consistently say that no members have any voting rights at all. And of course, that is ludicrous. But you can't take pieces of the law and apply them selectively to achieve your ends. And again, the part they quoted is inapplicable to the type of corporation they are. The attorney laid that out very clearly, and I am embarrassed to say, because they copied me on these, several members of the illegitimate board wrote the most unprofessional, abusive emails to this attorney. He's just doing a job. He's not part of this dispute. That was frankly embarrassing. Okay, so we're getting to the end here. So the part I wanted to read to you about members in a directorship model. In an earlier section of that same law that they did not quote, but controls. A corporation that is organized on a directorship basis, which is how they are organized, may or may not have members. If a corporation that is organized on a directorship basis has members, the members are not entitled to notice or to vote on any matter, including but not limited to any action denying, limiting, or otherwise prescribing their rights as members or excluding them from membership. So if the illegitimate board was going to be consistent and argue that this directorship model of corporation has members, those members have zero voting rights, and they will have just disenfranchised the entire membership of the Libertarian Party of Michigan. Of course, that's not the case because none of this is applicable to the party. But if they're going to claim that, they have to take it all the way and say no members have any rights at all. So the LNC is bound to recognize the leadership that is determined pursuant to their bylaws processes, which is to abide by their own judicial committee decision. If the Brungart board felt that the LNC was wrong on this, they can appeal to the National Judicial Committee. They have chosen not to. Their time's running out to do so. For them to potentially argue, well, we wouldn't win because that judicial committee is by, whatever they might argue, that they know the composition of the judicial committee and they wouldn't win. All that is saying we're going to do what we want to do, even if it's not in accordance with the rules of the voluntary society we're in, because we don't have the votes or the support. And that is just completely illegitimate. It's complete disregard for the processes we all agree to by being a voluntary member. So this is longer than I wanted, but it is the simple rundown of what happened. There are a lot of rabbit trails people go down that are irrelevant. The bottom line is the way to fix this is at a properly noticed convention, which the unhappy members demanded and they got, and they're now refusing to participate in, instead setting up a competing convention on the same day. That's completely outside the bylaws and the duly recognized board. An argument that's been made is this list of signatories of some very, very distinguished members of the party that are siding with the Brungart board. I'm going to say this, and some people might find this offensive. It does not matter how long you've been in the party. You do not have more rights than someone who has been in the party for less time than you. Being in the party, having significant accomplishments in the party, being a distinguished member of the party does not grant you the rights to flout the bylaws or more rights than people who haven't been in the party as long as you have. I find the suggestion that that's the case completely offensive. They had and still do have a very clear path to resolve this issue within their bylaws, and so far they are choosing not to. None of this summary requires anyone to agree with the decision of the Michigan Judicial Committee. But per their bylaws, the membership and the board are required to abide by that decision until they can assemble in a duly called convention. It really is that simple. This is a very simple case. Everything else truly is a red herring. And there's been a lot of what I call rules for radicals, elephant hurling, and personal attacks that have gone on. Now, if there was any particular rabbit trail, and I don't mean that in a disparaging way, but additional detail you wanted, like dates or names or whatever that I didn't give here, you can get in touch with me. I would be glad to clarify anything for that. But this is for the people that don't want all of that information, just want the low rundown. And that is what happened. This is a very simple dispute of a group not liking results and flouting the bylaws. And that just cannot be tolerated in a voluntary society. They need to go back to the bylaws, the recognized affiliate, and win at convention. And may the person with the most votes or the people with the most votes win. Who wins is irrelevant to the LNC, as long as the proper processes are followed and member rights, including rights of absentees, including rights of the significant minority, which are all protected through proper notice requirements. I hope that helped clear things up a bit in just a very sober, non-emotional way. My email is karenannharlos@gmail.com if you have any questions. And my phone number is public everywhere. I really don't want to stick it on a YouTube video, but it's in my signature line on the LNC. It's in my Facebook profile. You can get it quite easily, and I would welcome any phone calls. Have an awesome night or day or whenever it is that you're watching this.